session. Morning, please be seated. All right, we're here for oral argument in our case number CR23-0525, State v. Simental. These proceedings are being video and audio recorded and live streamed, so we please ask counsel to identify yourself and your client at the beginning of your argument. Each side has 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if you want. Also, please keep in mind that we've read the briefs, have conferenced the case this morning, and with that, counsel, you may begin.
Thank you, Your Honor. May it please the court, my name is Jill Logan. I'm a Rule 39 certified student. I'm working under the supervision of Randy McDonald, who is seated at the counsel table. I would like to reserve 3 minutes for rebuttal. The trial court abused its discretion in 3 ways in this case. 1, by refusing to grant an evidentiary hearing, though one of the parties created a genuine dispute of material fact and requested a hearing to resolve it. 2,
Counsel, what is the dispute of fact?
Your Honor, the dispute is whether or not the amount Ms. Simental possessed was eligible for expungement. 2, by relying on inadmissible and unreliable evidence that the marijuana in question was 1 ounce over the expungible amount to deny the petition for expungement. And 3, by shifting the burden to the petitioner to prove that her conviction was eligible for expungement instead of holding the state to its burden to prove that it was not eligible.
I guess drilling down on the factual issue, is that an issue because there's a constructive possession problem?
Your Honor, it's an issue because there's nowhere in the record that has been proven by clear and convincing evidence how much Ms. Simental possessed.
I assume that the grand jury transcript said what the amount was?
Your Honor, the grand jury transcript says that the amount involved was 102 grams, which is 1 ounce over. However, we would argue that the grand jury transcript is unreliable. There was a portion of that grand jury transcript where the officer said the reports were confusing and he was having a hard time following them. He actually mentions that, I believe, twice in there. Additionally, there were 2 co-defendants involved in this case as well, so there's never been any facts proven on the record as to how much Ms. Simental possessed. At the time of her conviction, the lowest amount she could have been convicted of possessing was under 1 pound.
I think it's a case Santiago said that the court can rely on pleading to documents that would otherwise be hearsay in deciding whether expungement is appropriate. And I take your point that there may be hearsay in the grand jury transcript, but does that make it inadmissible for these purposes?
Your Honor, I believe it does. This court in Santiago has held that an expungement proceeding is a criminal proceeding, and as such, the rules of evidence apply, which would make hearsay inadmissible. But even if this court were to accept the hearsay as evidence, we would still argue the reliability of that evidence. It was essentially an officer reading from a report. There was no evidence technician. We don't know how the evidence was weighed. Again, this is 1 ounce over, which, to give some perspective, Your Honor, is the weight of a single slice of bread. So if this evidence was weighed in packaging, if it was weighed in a container it was found in, that could have easily added the ounce on that made this ineligible for expungement.
So really, there are 2 issues then. Was the trial court correct in turning to the transcript at all? And I think your argument is no. But even if it was, the transcript still wasn't enough to satisfy the state's burden, right?
Yes, Your Honor.
Okay. I guess one issue, threshold or administrative issue I have is that we don't have the grand jury transcript in our record. Because we get the record from, I think, the appendix that you all filed, and the transcript's not part of that. So I'm not sure how I can determine whether the transcript was enough when I don't have it.
Do you have the transcript?
I do not have it with me, Your Honor.
No, but is it in your possession? Do you have it?
Yes, Your Honor. We have portions of it. It's very hard to read. It's very faded. But we have that testimony where the officer says the case involved 102 grams.
Would you be able to submit that to us?
Yes, Your Honor.
So for purposes of the argument, then, the transcript reflects a police officer testifying about what is in a police report?
Yes, Your Honor.
Okay. So you have double hearsay then?
Yes, Your Honor. So that is the issue that we have with the trial court, relying on just that transcript.
And did you argue that below, that there was double hearsay?
I'm sorry, Your Honor?
Did you argue that there was double hearsay below?
Yes, Your Honor.
And what did the trial court say about that?
We argued that in our opening brief for this court. We did not argue that in the trial court.
Okay. That's my question.
Right. So in 2020, when the voters passed Proposition 207, they very explicitly put the burden on the state to show by clear and convincing evidence that it was not eligible for expungement. And so in this case, the state hasn't shown any admissible evidence, let alone clear and convincing evidence, that the amount Ms. Simental possessed was over the expungible amount.
I guess, so, I don't know exactly how to pronounce Santalanes, is that how we pronounce that? Okay. Santalanes it's a bit internally inconsistent, because I think you're right, it does say it needs to be admissible evidence, but then it lists the sorts of things the trial court can turn to, including pre-sentence report, police reports, and I think your point on the transcript is that's hearsay. Wouldn't police reports and pre-sentence reports also be hearsay? So how can we say the transcript is not good enough, but those other things in Santalanes are?
Because, Your Honor, those would be all proven on the record once sentence is imposed. We don't have any of that. So we have the plea agreement, the change of plea minute entry, the indictment. None of that has a specific weight that Ms. Simental possessed. Everything.
How would a police report be proven on the record at sentencing?
Not that it would be proven on the record, Your Honor, but it would be kind of incorporated in there if they pled guilty, or if they were found guilty, or if the officer testified to what was in the report. I just lost my train of thought. So Santillanes does list things that can be looked at outside of the record, but those, it specifically says, are to determine if it can be denied on its facial basis. So this court has also, like in State v. Hobson, denied a case where it was a conviction for a heroin charge, not a marijuana charge. And the court said that's fine because it's facially ineligible. So, and the court in that case looked to the plea agreement and the change of plea minute entry to determine that what he pled guilty to was heroin.
Counsel, if you can look at police reports and pre-sentence reports, which I think would have multiple layers of hearsay in them, and Santillanes says that the court can consider them for purposes of determining expungement, what makes a grand jury transcript different from those?
Your Honor, I would argue that the grand jury is, again, it's the hearsay within hearsay, and because there were 3 co-defendants together in this case, and even when their grand jury was questioning the officer, he was having difficulty with what house they found what amount at, and he couldn't follow the reports. So I would say, even if this court were to consider the grand jury testimony, we still have an unreliability issue.
How about the trial transcript itself, I know that's not an issue in this case, but could a superior court look to testimony in the underlying trial itself, or would that be off limits too, in the same way that a grand jury transcript is?
They could look to trial transcript, Your Honor. So anything that has been a fact finder has found to be the case, which we didn't have in this situation. So there was no fact finder who determined that this was the amount of weight of marijuana that Ms. Simental possessed. It was just simply under 1 pound, because again, at that time, with the statute that was in place, that was the lowest amount she could have been convicted of possessing.
Well, the fact finder, I think, is just going to determine whether it was more or less than 1 pound, right? So aren't you still going to have the same issue with trial testimony that you do with grand jury testimony?
Your Honor, if it was prior to the statute change, then yes. But again, I believe that's what the voters had intended when they created this presumption of expungibility, is these low-level marijuana possession convictions. People would be able to get them expunged and be able to kind of have a clean slate. And so while we may have older cases where it was only charged as under 1 pound, that doesn't lessen the state's burden to show by clear and convincing evidence that it's not eligible for expungement.
I mean, I guess one difference between a trial transcript and a grand jury transcript is, with a trial transcript, you'd have the benefit of cross-examination, right? Grand jury, it's just the prosecutor getting up and eliciting testimony for one side, and you don't have the testing of cross-examination.
Yes, Your Honor. And the other issue we have is, at the time, because of the way the statute was written, there was no impetus for precision in weighing the marijuana. It was less than 1 pound or over 1 pound, and this was very clearly less than 1 pound.
Do we know from the transcript, was the marijuana all in one place, or was it spread out throughout? Was this a residence? I think it was a residence, right?
It was a residence, Your Honor. They conducted, I believe, 2 search warrants on 2 separate residences, and they found drugs in different locations. I believe this was in one place, but again, we don't know how it was packaged or if it was in a container when they weighed it, and because it's only 1 ounce difference, we would request an evidentiary hearing to be able to subject an evidence technician to cross-examination to how it was weighed.
Do we know who owned the residence?
I don't know, Your Honor. Okay, so if there are no other questions, Your Honors, I would like to reserve the rest of my time for rebuttal.
Okay.
Thank you.
Excuse me while I get spread out here. And good morning. May it please the court. My name is Jason Easterday, and I represent the state in this matter.
If I may begin, you have a copy of the transcript?
Yes, Your Honor, I do.
Is it a more full transcript than I think your colleague said?
I agree with my friend that it can be hard to read, but however, the officer who testified at the grand jury was sworn and was one of the arresting officers in this investigation. And on page 9 of the grand jury transcript, the officer indicated that he was the one that spoke to the defendant, Ms. Simental, and she was the one that indicated that she possessed marijuana, and when they went to find the marijuana where she indicated where it was, I'm paraphrasing, by the way, that they found marijuana packaged in 2 bulk packages that came to 102 grams. She told the officer who testified at the grand jury proceedings that she possessed it for sale.
This is his direct testimony, or this is his testimony based on what was in his police report?
This is his direct testimony. Question: did she tell you she possessed that meaning the marijuana,
right,
for sale or for personal use? Answer: she told me she possessed the marijuana. She intended to sell it, and she And it's really hard to read at that point. I don't want to waste all my time, but it goes off from page 9 to page 10 in the grand jury transcript.
Is there a hearsay exception for grand jury transcripts?
Well, in this instance, there's no hearsay involved in this court because it's actually not considered hearsay because it's a statement against interest by the defendant herself. So she possessed the marijuana. And Judge Howe, I believe you hit on something that I have in my notes, that because the appellant failed to include the transcript in which they take issue with, I'd like to read from State Ex Rel Brnovich versus Miller. When an appellant fails to include all transcripts or other documents, bracket, this court assumes the missing portions of the record support the trial court's findings and rulings. So because the appellant failed to include the grand jury transcript in which they take issue with, this court is to assume that it supports the trial court's records, and the Superior Court in this instance properly considered the evidence to support its findings.
So there is no double or triple hearsay involved?
I don't believe so, Your Honor. Again, the arresting officer said that she told me. That indicates that there was a personal conversation between the defendant.
Isn't that his statement about what she told him? So that's still hearsay because it's him recounting what she said. It's not her direct statement. If she had gone in front of the grand jury and said, I told him, and that was our statement in front of us, then that would be a statement against interest. But this is the police officer's statement, so it seems like that doesn't fall within the exception.
Respectfully, I disagree because based upon the reading of the transcript, she informed the officer, and the officer then informed the grand jury about her statements.
But we're not the grand jury, and neither was the Superior Court. So at the time that it was in front of the Superior Court, the grand jury transcript of the officer's testimony, which was not being, the officer wasn't there, right? In front of the Superior Court as it was considering this expungement motion 30-some years later?
There's no indication of that, Your Honor. However, I would like to point out that...
I mean, are you trying to infer it could have been the case?
No.
Okay.
Your Honor.
Right,
So-
there's no evidentiary hearing here, so we don't
Correct.
we don't have the officer testifying.
The officer was sworn, however, for the grand jury proceedings.
But the issue, though, is not so much whether she says she possessed it, but whether the amount was over or under the expungement.
Yes, Your Honor, and the grand jury transcript does say it's 102 grams. There's no indication about how that came about in full candidness. However, the defendant during the proceedings before the Superior Court did not make that a genuine issue of fact to trigger a potential hearing. Under Rule 36, the Superior Court may, not shall, may, in 2 instances, order a hearing if either party requests it, which is not the case here, or there's a genuine issue of fact in dispute. Now, a genuine issue of fact is an undefined term in the statute and the rule, but it does eerily similar to the summary judgment language. And the defendant never objected to the state pointing out that there was 102 grams in this instance. There was no reply. There was no motion for rehearing. And even in the briefing, the defendant never said anything that she possessed anything under the 2.5 ounce threshold.
There was no contrary evidence presented at the grand jury or at the expungement hearing?
No, nothing at the grand jury. There was no evidentiary hearing, Your Honor, and the Superior Court didn't err because,
I understand that, but he never disputed the 102 grams.
Not in the pleadings before the Superior Court, Your Honor, no.
How does the 102 grams statement come up in the grand jury transcript? Is that based on a police report?
It's in the grand jury transcript. It's not cited how it is, how it came in.
But who says it?
The question from the deputy county attorney, 102 grams of marijuana, answer, yeah, total weight. And that's less than a pound, less than a pound. So there was a bit of a back and forth. It was grand jury.
I guess, see, this is part of my problem with grand jury transcripts, because I suspect at trial, if the officer said just 102 grams, you'd get an objection based on foundation or hearsay. Because at trial, I think the state would have to call someone who actually weighed the marijuana and had personal knowledge about how that weight was arrived at. The grand jury proceedings, you just have the officer getting up and you have a simple statement of 102 grams, right? Yes. So I think it's lacking some of the reliability that we might see in other documents that Santalane said we can look to.
Well, one, I respectfully disagree with that statement because the grand jury testimony from the officer was sworn. So there is that hint of a little bit more reliability. So if...
But how did he know that it was 102 grams?
That I can't tell you from
You
that.
don't know, right?
Apart from he felt confident enough to say it under oath.
I mean, what is the difference or the similarities? The two sides of the same coin, I guess, between the documents that Santiana says we can rely on and the grand jury transcript here. Are they the same or are they different?
Your Honor, I would say that the grand jury transcript has a heightened reliability because, again, it is sworn to some of those documents that I've been pronouncing it Santiana, so excuse me.
Yeah, I think I'm pronouncing it wrong.
Well,
I like
yeah.
that pronunciation better.
The S case, Your Honor, the Santiana, Santalane's.
Santianas.
Okay. Because I believe Santiana, as you indicated, said items like the police report and whatnot can be relied upon at the briefing stage. And again, in this case, there's a little more, reliability behind these statements. Because one thing I would like to point out is that the grand jury transcripts can be incorporated as part of the factual basis under State versus Sodders, and I believe there's a criminal rule procedure that I'm blanking on right now that says that grand jury transcript, pre-sentence reports, and all the other documents that Santalane and Santianas can rely upon can be incorporated as part of the factual basis. So the grand jury transcript, while there's no indication the Superior Court during the change of plea hearing or sentencing indicated it was incorporated by reference to grand jury transcript, by rule it can be. So it is part of the record, and it can be considered, the state asserts.
So when a defendant pleads guilty, the grand jury transcript can be considered part of the factual basis.
Yes, Your Honor.
And it's even with all the hearsay that may be inside of it.
Yes, Your Honor. In addition, the pre-sentence report can also be incorporated as part of the factual basis. And
Police reports?
pre-sentence report, excuse me.
No, you said pre-sentence report.
Okay.
I'm asking, can police reports? Santianas mentions police reports. I struggle with that being consistent with its statement that it has to be admissible evidence.
I'm unfamiliar. Educated guess, Your Honor, no police reports, but I didn't go deep down into that research about that.
And I guess I have a question about the grand jury transcript being relied on and incorporated as a factual basis. That's complicated here because the factual basis it would have been targeted at in this case was the 1 pound or less. We're not dealing with that factual basis for purposes of expungement. So doesn't that complicate this sort of reliability question here when the transcript you're looking at wasn't considering this fact?
No, Your Honor, because to
Judge Catlett's earlier point, in a grand jury, there's no testing. There's not a cross-examination. Even the colloquy that you described to us, it's the prosecutor setting out the amount. There's no testing of it. There's no identification of the source of that amount. to your colleague's point, we don't know what all was weighed together. Was it the wrapping? Did that play a part in the gram amount? Those sorts of things. So don't those start to raise some complicating factors on this factual basis question?
No, Your Honor. Because again, the Superior Court could rely upon it in determining the factual basis, and the Superior Court can then use the factual basis in its sentencing analysis as well. So,
But again, that's a different factual basis than we have here, so that's not really an answer to my question.
yeah, at the end of the day, though, Your Honor, this court is being asked to reweigh the evidence before the Superior Court in deciding whether the Superior Court properly found the 102 grams was proven by clear and convincing evidence, which is not the province of the Court of Appeals. It's to
I think my job is to decide whether there should have been an evidentiary hearing, maybe at the minimum.
and under Rule 36, none of the triggering mechanisms were present. Again, under
But I think
36.
the portion of Rule 36 that you're relying upon is or if the court finds that the offense identified in the petition is not eligible for expungement.
Under 36D3, yes, and under this court's precedent under Cisneros, which CISNEROS, I don't know if I'm pronouncing that correct, it indicated that the Superior Court could review at least the extended record, which the grand jury transcript would be a part of, to determine whether the matter is expungible.
Yes.
Because I believe Cisneros used the court can independently act as the gatekeeper to ensure that proper cases are expunged properly.
I guess I'm confused about where that portion of Rule 36 even comes from, because it's not in the Act. Maybe that's a question better directed to my colleagues on the fourth floor who drafted the rule, but
Yes, Your Honor, and because the Supreme Court drafted the rule, and it doesn't appear to be inconsistent with the ballot initiative in the statute, so I asked this court to read everything in congruity. But the rule I was referring to was 36C1, Your Honor, and that is the Superior Court may set a hearing on the petition on either party's request. No party unconditionally requested a hearing in this matter. The defense didn't, and the state only asked for a hearing if the Superior Court found the record review is insufficient.
Counsel, when the state offered the grand jury transcript, what did defense counsel do? Did they objected? Did they explain why they objected?
There was no reply to the state's response to the expungement petition. So an argument can be made that the defense waived the amount of marijuana in question by the failing to object, or failing to, under Santillane and Santillanes, by failing to request a hearing.
And they didn't file a pleading saying that the amount stated in the grand jury testimony was wrong or incorrect?
Nothing like that, Your Honor. There was no reply whatsoever to the state's response to the expungement petition.
If the contents of the grand jury transcript raised a question of fact, regardless of the defense actions or inactions, was the court obligated to hold a hearing?
No, Your Honor. The second part of 36C1 was the court may set a hearing if the court concludes there are genuine issues of fact regarding whether the petition should be granted. In this instance, the defense would...
So if the court wrongly concluded that there was no genuine issue of material fact, do we play a role in saying, but on its face, there is an genuine issue of material fact, in which case we would say that the court erred? What would be wrong with that analysis? Explain to me why it would be wrong for us to, as a matter of law, go that direction. I mean, is it your position that just there is no such issue of fact here, or that this court does not have an obligation to look at whether there was an issue of material fact?
There was no issue of fact at all because the state asserted 102 grams of marijuana and the defense didn't do anything. They didn't respond saying that was wrong. In fact, the only real factual assertion.
But you bore the burden here. You, as the state, bore the burden. And so I guess what I'm saying is this is what the state offers, is the grand jury testimony. And if we look at it and say on its face, the evidence that the state offered created a genuine issue of material fact, therefore the court erred in failing to hold an evidentiary hearing. What is incorrect about that legal analytical framework?
I'm sorry, Your Honor, I'm blanking on your question.
But I think under the statute, they move for expungement, and then it's the state's burden to show by clear and convincing evidence that expungement is not justified. The state here comes in with a grand jury transcript with an answer of 102 grams. It's an answer by the prosecutor to a leading question, maybe without foundation. The trial court says that's enough. Regardless of what the response was at that point, as the appellate court, can't we look at it and say, was that statement in the transcript in the context of everything the Superior Court had sufficient to show by clear and convincing evidence that expungement is not justified here?
I still come back to the point that it's asking this court to act in the Superior Court's shoes about whether the clear and convincing evidence standard was met, which is...
Well, we may not say she's entitled to expungement because of what the state came back with, but we may say there's something there, but it's not, there's some question, and therefore the court should have held an evidentiary hearing.
Even under Cisneros, the court may independently act as the gatekeeper to ensure that it's an expungible proceeding, and in this case, the Superior Court acted
But
as that
it's
gatekeeper.
possible for the court to make error in playing that role, I guess, is what we're getting at here. Yes, it is the court's role as a gatekeeper, and yes, the court could reach that conclusion. What are we to do if we look at it and say on its face that was an erroneous conclusion?
If the record also bears out that in addition to the grand jury transcript, the pre-sentence report, which I believe is also in this court's record at ROA 97 at numbered page 1, also lists 102 grams of marijuana.
And we can rely on that under Santiago.
Yes, Your Honor, because again, I think that would fall under the pre-sentence report under State v. Sodders, and the rule that's still I'm blanking on can be incorporated as the factual basis, to support the factual basis. So, Judge Perkins, I guess my time is up.
You're out of time, counsel. Thank you.
Thank you.
Ms. Logan.
Your Honor, it's our position that when the state objected to the expungement proceeding, it created the material dispute of fact. This court held in Santianes that where there is a genuine dispute of material fact, the court must hold an evidentiary hearing. And the Superior Court was bound by this court's ruling to hold that evidentiary hearing where the dispute of fact.
So I take your position is that the grand jury transcript itself is sufficiently questionable that by itself, but that it necessarily creates a dispute of fact?
Your Honor, we believe the offense to be expungible. The fact that the state believes it has not created the dispute of fact, we believe that the grand jury transcript is inadmissible and unreliable as far as the weight, because that officer was not subject to cross-examination. We don't know, again, how it was weighed. We don't know where it was found. There's a lot that's missing. And so the state says that we didn't file a response, and we didn't because the state asked for an evidentiary hearing to resolve any material dispute of fact if they didn't rely on the grand jury testimony. And we assumed there would be an evidentiary hearing because the grand jury testimony is not admissible, where this court has held that expungement proceedings.
Well, the state said rule in our favor, and if you don't, then give us an evidentiary hearing, right?
Yes, Your Honor. But they said take into account the grand jury transcript. Reading this court's ruling in Santillanes, it says that only admissible evidence can come into an expungement proceeding.
But then there's several documents that we all agree would continue saying not be admissible, so that's inconsistent. And I guess my additional question off of that is that your colleague points at the pre-sentence report has the amount in it, and so as long as the trial court can rely on that. So regardless of the grand jury transcript, we've got something that this court has held that the trial court could rely on.
Yes, Your Honor.
Do we know where the pre-sentence report got the 102 grams? Maybe from the same grand jury transcript?
Probably from the same grand jury transcript, Your Honor. I do not think I have that. I have the plea agreement and the factual basis of the plea, and that all states just under 1 pound was the amount that she pled to. And again,
Sorry to interrupt. Is it your position then that anytime the state objects, the trial court has to hold an evidentiary hearing?
Your Honor,
You didn't say that in Hobson, and I know Hobson's an unpublished decision, but I was on that panel, and I don't like to be inconsistent from panel to panel, so.
Your Honor, that is not my position. My position is where the state creates a material dispute of fact, or either party creates a material dispute of fact, there needs to be an evidentiary hearing unless the court can look at the face of the expungement and say it's not.
Right, you're
like
saying the grand
a
jury
heroin.
transcript here was not enough to put us into that facially obvious category of cases where no
Yes, Your Honor.
evidentiary hearing needs to be held.
Yes, Your Honor. I think the state hasn't met its burden of clear and convincing that the voters clearly imposed on it when they passed Proposition 207. And again, I don't think the court would have to hold one in every instance. There are times where, the plea might say, I plead guilty to possessing 2 pounds of marijuana. And obviously that's on its face not expungible and wouldn't require a hearing. But in an instance like this where a fact finder has never made a finding of the weight that she possessed, and the weight that is alleged in the grand jury transcript is 1 ounce over the threshold, I would argue that there needs to be an evidentiary hearing to figure out how this was weighed and if it's an expungible conviction.
I take Judge Perkins' point that the factual basis for the guilty plea is different than the factual finding that needs to be made here, but the evidence is the same. The evidence that would be submitted for the guilty plea is the same as evidence here, the grand jury testimony. So, other than the particular finding that has to be made, the evidence is the same, and the evidence makes the same point that was over the amount. So if it can be considered for the guilty plea purposes, why can't it be considered for the expungement purposes?
Your Honor, I would bring up the change in the statute since then, because again, there was no impetus for precision. It didn't matter if it was an ounce or 5 ounces, as long as it was under 1 pound. So there wasn't a need to be as precise as we now need to be to show that it's expungible. So because the officer that testified in the grand jury was not subject to cross-examination, because we don't know how it was found and how it was weighed and where they got that number from, I think the only way to resolve that issue would be with an evidentiary hearing. And then the other point I wanted to hit is the state said that the defendant didn't allege in the petition for expungement that she possessed less than 2.5 ounces, but that's not her burden. And the voters were very explicit with who bears the burden. And again, this time in Arizona law, there's going to be many of these convictions that are under 1 pound because that was the statute. And so it's again, you can't shift the burden to her to show I only had an ounce. Or the burden is on the state to prove by clear and convincing evidence that what she possessed was over the expungible amount. If there are no other questions, Your Honor, that's all I have.
No,
Thank you.
Thank you very much to both of you. We will take the matter under advisement and have you a decision in due course. Thank you.